everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. How can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me? Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you
It's another Saturday afternoon with us lovely people. It's the community and the law. My name is Oreku Frimpon, and I'm delighted to be back with you on the program The Community and the Law, brought to you by BWF Solicitors and live on BW TV, on social media platforms, Facebook, YouTube, and what have you. How do you successfully apply to remain in the UK based on your private life? This is going to be up for discussion. So I would want you to join me and my resource person, guest and friend, Lawyer Charles Asma from BWF Solicitors, as we delve into it. It's the community and the law. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BW TV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BW TV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BW TV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950 422780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
It is pretty important that you know how to maintain your status as a legal person here in the UK if you do not come from this country. When you migrate from wherever to live in here, whether to join your partner, whether to join your family, or as a dependent of any of the persons that have a right to live here, you would want to maintain that legal status and be able to go about your duties freely and legally. This afternoon, we're going to look at what private life is and how to even apply and stay here in the UK legally based on your private life. We are here live on the program The Community and the Law, brought to you by BWF Solicitors. My name is Oreku Owusu Frimpong, and I'm delighted to be your host this afternoon. I've got all the questions you want to ask, and I know definitely if I do not ask all of them, you would have the opportunity to bring them in when we activate the lines 0208-493-7345 or 07399-208-468. We have the opportunity for you to be able to reach us both on text message and on WhatsApp 07399-208-468. And as I said, I'm coming your way courtesy BWF Solicitors, located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Fridays between 9:30 in the morning and 6 p.m. And if you want to get in touch with them over the weekend, you have to book an appointment and they will make room for you. BWF Solicitors sees to all our immigration matters, all our legal issues, interpretations, and the rest of it. They help us to go about our applications, help us to make our appeals and represent us in court and all the rest of it. And then again, if there's any legal interpretation or update from the Home Office or the Secretary of State for Home Affairs, they are there to help us. So if you are on this platform, you are here for a full package. And as I said, I am going to be having a discussion with one of the lawyers of BWF Solicitors, lawyer Charles Asma. And again, I want to say we're going to look at the topic how to successfully apply to remain in the UK based on your private life. Well, let me first of all bring on lawyer Charles Asma, welcome in. And as the tradition of this program goes, he would say his greetings and then we'll pick up the updates, we'll do our nuggets, and then come into the main discussion. So if you just joined us live on Facebook at BWF Solicitors and on YouTube at BWF Solicitors and also at BWF Solicitors both on Facebook and YouTube, BWTV is also available. So you can share those pages and all that. I'll be welcoming you, but first let me do that with lawyer Charles Asma. Lawyer, good afternoon.
Good afternoon.
Thank you so very much for sparing us your time this afternoon, and we're so delighted that you do that, and we definitely have questions to throw at you.
It's always a pleasure to assist the community.
Right. Well, as I said, with a smile, he says it's always a pleasure to assist the community. Now, let me see who I have from the community in our midst. Well, I can see so many of you on there. So what I want you to do when you join us, put your make your presence felt in the comment section down either on Facebook or YouTube, BWF Solicitors and BWTV. Sandra Feza is the first person whose name is drawn out of the hat. Good afternoon, Sandra. Thank you very much. Hello, lovely family. This one from Tilly Duma. Tilly, thank you very much. You always do what you do, and we appreciate you for that. Bernard Tete is also announcing his presence. Bernard, thank you. Good afternoon, Benny. Then I did share. Oh, yeah. That's really good. Thank you so very much. That's exactly what I expect everybody to do when you do join us. So thanks for sharing. Please kindly share, comment, and like. Thank you, Tilly. We'll give you a thumbs up for that. We've got various other people on here. Dr. Sakwa, you're watching with us. We have Hasif Camille, you're also watching with us. Well, I've mentioned Bernard. Thank you. Lezadnie. Thank you. Manetia, you've been called. You're watching with us. Kwesi Koram and a host of others. So if you come in, please let me feel your presence. I'm here and I'm going to help have that discussion go on. Visit BWF solicitors, presented their cases to them, asked them to represent them and all that, are happy and giving recommendations here and there. We have Quay here. Hagar is saying that look no further because BWF solicitors is the best place for your immigration process. I started with nothing, but now God used them to help me. I am a British citizen. I highly recommend their services. Now, if you go on to Google, you can put in BWF solicitors and drop in your review as well. Then people will have a feel of that wonderful piece of service you have enjoyed from BWF solicitors. So, Hagar, thank you for sharing your experience with us. Yes, definitely we're looking no further than BWF solicitors. There are a few updates that I need to share with you, my brothers and sisters. UK government has issued new advice to all those traveling back to the UK. And the advice is that you need to generate your share code. What kind of share code are we looking at? The Home Office entering the UK guidance has been dated further to the 4th December 1. The guidance now states that persons who hold an e-visa should obtain a share code from the View and Prove service before they travel overseas, as this may be needed by their carrier to check their immigration status. The share code is a unique 9-digit alphanumeric code that provides a person's right to work in the UK. Uh, I want to reiterate that a share code, as per the regulations and guidance, is valid for 90 days. Well, I'll be coming back to that. I'll be asking lawyer Charles Asma to help me unravel this and explain it a bit further. I know people are all contemplating what has the deadline been extended, what's happening, because we know that by the 31st of December 2024, all BRP cards would expire. And then what will you do? What do we do? How do we generate that? And then now we're being asked to generate share codes. So definitely we need some further explanation, don't we? Okay, now let's move on to our nugget for the week. Now, if you are just joining us for the first time on this channel and on this program, we have the community and the law come up your way every Saturday between 4 p.m. and 6 p.m. here in the UK. Now, what we do is we bring something, an update, an explanation of the law. We set it out in a case so you really have a full grasp of that. And BWF Solicitor does that and releases the nugget every Monday by 12 noon. So if you are part of their social media networking world, you would have seen this. But when we come on the program, we try to reiterate it. And this is what I'm going to do now. It's talking about disciplinary actions at work. Then the question is, yes, those things can happen, but is there a time limit for disciplinary action at work? This one says, in the UK, there is no statutory time limit explicitly set in the employment law for how long an employer has to initiate or complete disciplinary actions. However, employers are expected to act promptly and handle disciplinary matters in a reasonable and timely manner to comply with best practices and employment law principles. In the case of Williams versus Leeds United Football Club, the High Court found that in principle, there's no limit on the length of time that can pass between an employee's gross misconduct and their dismissal without notice if the employer was unaware of the employee's wrongdoing during that time. What is this one trying to tell us? Well, I've got two things that I need lawyer Charles Asma to help us explain. So I'll go to the first update and then come on with lawyer Asma to help us with that. What is this new directive that the UK government has issued? Well, this one says advise. If it's advised, is it mandatory or what? Lawyer Asma, please kindly help us clarify this.
Thank you very much, viewers and listeners. So today's update, as has already been said, is advice to travelers to the UK. We know that the 1st of December 2024 is the deadline for everyone to apply for the e-visa or enroll their data onto the e-visa platform so that the immigration officers can locate your visa status. Employers can locate visa status and so on and so forth. The focus from the update or the advice is about immigration officers. Mm-hmm. So if you are traveling from abroad to the UK and you have not already enrolled your e-visa, we know that there are issues with e-visa where people are not able to do it, and those who have done it even have issues with different dates. The dates being picked are one on the pass, the one on the card, and the one on the decision letter. So there are a lot of complications, and the government is aware that these are happening. And the question is, if the government doesn't do anything about it, then it will be unfair to punish those innocent residents in the UK simply because they have not been able to enroll onto the e-visa platform. Mm-hmm. So the government has decided that If you haven't enrolled e-visa, that should not be the end of it. However, there's grace period. It's not that they have extended,
Okay.
it's not an extension, but to ensure that everybody's needs are met. If you are entering the UK for whatever, some people have already traveled abroad, and if you are outside the UK, you cannot enroll. So you have to be in. There are so many other parameters. So what the government has said is that up to March 2025, if for whatever reason it's not done, you need to still use your share code. So the share code will be available. You give the share code to the immigration officer or whoever needs it, and the person will be able to track your status. And the status will indicate that yes, your visa expires at a particular date, or you have this, you have that. And that is what the government, for those entering the UK. So if you are abroad and you don't have the e-visa enrollment already done or complete, you have to ensure that you have your share code. What is share code? It is your visa that has been transmitted or converted to a code. And the code is made up of numbers and letters. So all you do is go on the platform, just type or Google share code. Then you go on, follow the instructions, enter your details, you generate your code. Give it to the immigration officer who will use it to check whether your visa is valid, and so you should be given a pass into the UK. The code expires in 3 months, and therefore, if you generate it, you can keep it for 3 months before you have to regenerate. That is what the government has proposed.
So Laura, just hold your thoughts there. What is happening here is that if you are not able to um, enroll onto your e-visa account and link your status to it and your BIP and the rest of it to it, but you have a share code that is valid, you can use that to travel and come back into the UK. Then you take advantage of the grace period, which is the end of March 2025. Is that what is happening now?
Right. So it's not, and that is the confusion, because people think that all right, okay, I have been the time is extended. It's not an extension per se, but there are people who might have even enrolled, but there are complications with the whole e-visa platform.
Mhm.
And so the share code is able to confirm your status, your immigration status in the UK.
Okay.
So if you look at the update, the information that we shared, it says the guidance is clear that if you can read the third paragraph, okay, second paragraph after the head.
It says the guidance now states that persons who hold an e-visa should obtain a share code from the View and Proof service before they travel overseas, as this may be needed by the carrier to check their immigration status.
So we are more or less targeting, much as the immigration officers need to have this, the carriers are also not sure what's happening, because the carriers are the airline staff. They do not have the understanding of how all these things work, and therefore the simple thing for them is your share code. Okay, we put in your share code, your visa is there, you can travel. So these are the things that the government is trying to do to ensure that people can travel to and fro. But what about those who are not able to do the enroll their e-visa itself? It appears that the guidance or the update targets those who are traveling abroad,
Mhm.
and for whatever reason, they have to confirm to the airline operators. But what about those traveling, entering the UK because they've been abroad before them, they've been away, they have not been able to generate their or enroll their e-visa and are traveling to the UK? Would they also need share code? I would say yes, they also need a share code. For much as we are looking at those who are traveling from the UK to or traveling abroad, what about those traveling in? So this person who is traveling today, what about if when they are returning? They also have to show the share code or prove their residence by way of the share code. What about the immigration officers abroad who may want to see that the person has already gone through the transition process? So they say, and that's what the government is saying that, all right, by March 2025, at least the teaching processes would have all been ironed out and it will be clearer what the approach is. But for now, suffice to say that share code will be the transitional approach to ensure that people are not disadvantaged in any way. Simply, if you are traveling, make sure you've generated your share code, add it to your passport. If you are coming in and you can generate a share code, do it, add it to your passport. Either way, when it is needed, you give it to them, either to the immigration officer or to the airline. If you are living in the UK, no immigration officer will be bothered about your residence. But it's only when you are entering the UK that it becomes an issue whether you have residence or not.
Well, when it comes to share code, we know that there may be different type of share codes. One for your employment, one for you to be able to rent accommodation, and then to open a bank account. Is there any particular one you'd have to generate before you travel or present to the carriers, so to speak?
So because it's about residence, you have to generate the one that has to do with your immigration status.
Okay, right. That's clear. But if anybody has any question or any issues, concerns you would want to bring to the attention of BWF solicitors and particularly lawyer Charles Asma, please send us a text on 0739920848. 0739920848. You can send us a WhatsApp message as well. Or later on, when the lights are active, you will be able to call us on 0208 493 7345, 0208 493 7345. Or you can call Lawyer Asma himself. He calls his line the Line of Hope. You can call himself on 079 47 63 6037, 07947 63 6037. Yeah, thank you for this one. The next one is the nugget where we're talking about disciplinary action at a workplace, the employer and employee relationships, where there's been a misconduct, gross misconduct, and there's supposed to be punishment. The question is there a time limit for disciplinary action at work?
Thank you very much. So the nugget is clear that there's no time limit. However, there's common sense approach. And the common sense approach takes us to the principle of fairness and justice. So there is aspect of law called the law of equity. And one of the principles or maxims of equity is that delay defeats equity. So that if you have to do something, then you have to do it on time. Otherwise, the delay can cause your right to do or to take action. Now, we are looking at an employer who has policies and procedures in place. And one of the policies and procedures has to do with conduct of employees. And as far as is possible, the conduct of the employee, if it's grievous or gross, must trigger dismissal or termination. And the handbook of the employee will be clearer which aspect of the behavior or conduct will be minor and aspect which may be grievous or gross. And so if it's a gross misconduct, it triggers summary dismissal, where you do not have to be told that you are going to be terminated. So there's no notice period for that person. Now, the question is whether any disciplinary action should be handled promptly or delayed. On the balance, If the employer is aware that this is the situation, then obviously we're going to take prompt action. Is that not the case?
Mm-hmm.
Yes, if the employer is aware. What if the employer is not aware of whatever has happened? Then somebody must whistle blow in the first place, or the employer must be aware before anything, an action can be taken. And so we are looking at where the employer is aware and where the employer is not aware and becomes aware later. Within, for example, a litigation spectrum, employment tribunal, you have, for example, 90 days from the date the incident occurred. If, for example, you are to bring action in employment tribunal against the employer. The next thing is, this is not about bringing action against the employer, but employer taking action against the employee. And whether employee can say that because he didn't do it on time, it's been waived. Does delay mean a waiver? That's the question within the nugget. And the answer is no. However, there is advice to employers that much as delay is not a waiver for taking a disciplinary action against an employee, the employer must also apply a fair approach to ensure that there is no undue delay. Otherwise, it creates presumption for the employee that the employer has not taken action, and for so long, and to the extent that it appears that it's been waived. And if you come back later after 6 months or 1 year or whatever period to say that this is what happened the last time and we are now taking action against you, so you are dismissed summarily, it will appear that the employee who has formed an opinion or impression that the employer has not taken action, because if action was to be taken, it would have taken long time ago, because it happened some time back, and all of a sudden being told that they are being dismissed or terminated because of their conduct or misconduct, that might not be fair. And so much as there's no time limit, it's also prudent within the principles of equity that because delay defeats equity, employers must ensure that they take disciplinary actions promptly to avoid over-reliance by the employee.
But then you're talking about common sense approach here, Laura. If the conduct needs to be thoroughly investigated, which brings in the issue of equity, then there must be as much time as possible available for whoever is leading the investigation to come up with some concrete results and findings, isn't it?
So there are aspects to this. If it's a matter of investigation, then the employee would have been told.
Okay.
If it's a matter of investigation, the employee potentially would have been asked to stay away from the investigation, because fair investigation means that the person might not be available as to interfere with the investigation process.
Mm-hmm.
And so you may be asked to stay away from the investigation whilst being paid.
Okay.
That is not dismissal. But we are talking about summary dismissal, where it has come to the attention of the employer that there's been gross misconduct to the point that the employee has breached a crucial aspect of the employee's handbook, which is the code of conduct for employees. Then the employer has the right to terminate the employee's contract. But the question is, when should this termination occur? Is it soon as it happened, that as soon as the misconduct took place, or when the employer became aware of the misconduct? Employer cannot take action against the employee to the effect of dismissal if the employer is not aware. And I'm sure you agree. If the employer doesn't know something has happened, why will you do anything? And so, if you look at the case that went to court, the case of Williams and Leeds United Football Club, it's a matter of when the employer became aware of the conduct and to the point where dismissal occurred. So if you read the third paragraph, if you can reiterate that for us.
In the case of Williams versus Leeds United Football Club, the High Court found that, in principle, there's no limit on the length of time that can pass between an employee's gross misconduct and their dismissal without notice if the employer was unaware of the employee's wrongdoing during that time.
And it's obvious that if the employer is not aware, there's no way the employer can take action. And so, insofar as the employer became aware later, then the action point start from that moment when the employer became aware. But if the employer became aware long time ago, then it will not be fair for the employer to rely on the case of Williams, because in the case of Williams, employer became aware later. But in most cases, if the employer has become aware long time ago when it happened, then why do you delay till 3 months later, 4 months later, 6 months later, when the employee has formed an impression that it's all over now and maybe the action has been waived? I don't know if you get that point.
Mm-hmm.
And so it's simple. Yes, there's no time limit as to when an employee can be terminated for gross misconduct. However, principle of equity applies that delay defeats equity, and therefore the employer must take action immediately. It's not about investigation, because when it comes to gross misconduct, there's no need for investigation. That's why we say gross misconduct or summary dismissal. So summary dismissal, there's no notice. But the point here is the employer's own policies and procedure will determine what needs to be investigated and what need not to be. For example, there are certain actions that could be on the basis of whistleblowing or complaint, or somebody mentioning it to reporting. Let's say reporting, let's put it that way. So if somebody has reported that this member of staff or my team member has done this, then that report must be investigated. But if it is obvious the person has been caught red-handed, then it's not a matter for investigation. It's a clear evidence, because there's something called res ipsa loquitur. It's a Latin expression which means the fact speak for itself. So if the facts are clear and obvious, then we don't need further investigation. And at that point, the employer must terminate right away the contract. But if you don't terminate, then we assume that maybe you have waived it. But if you didn't terminate because you were not aware and you became aware later, then fine. The moment you became aware, you have to terminate. So there are things that will call for investigation and things that will not necessarily call for investigation. And if it doesn't have to call for investigation, there's summary dismissal, which will be fair within the employment law.
Right. Okay. So, folks, I am going to give you a scenario and see if really we've caught the principle behind this. Let's look at this. Kwame Abbas was initially made redundant, but was summarily dismissed after his employer found that over 5 years previously, he had forwarded an email containing obscene and pornographic material to a junior female employee and 2 friends who were working at clubs. The employer sacked him summarily, although his contract required that he be given a 12-month notice period. So Kwame Abbas sued for breach of contract and for salaries in lieu of a 12 months notice. Look at it again. This man, Kwame Abbas, was initially made redundant, but was summarily dismissed after his employer found that over 5 years previously, he had forwarded an email containing obscene and pornographic material to a junior female employee and 2 friends who were working at clubs. The employer sacked him summarily, although his contract required that he was given a 12-month notice period. He sued for breach of contract and for salaries in lieu of 12 months notice. The question I'm asking is, will his claim succeed because he was not given 12-month notice? Well, this is quite straightforward. It's either yes or no. But then there's an explanation to whether you pick yes or no. Now, let me look at it this way. Yes, as his contract stipulates a 12-month notice, it ought to be respected. Then the other question, the other answer is no, because the offense is a gross misconduct, which does not require a notice period. So put this vis-a-vis the nuggets that we had, and then think about it, because at the tail end of the program, I'll be asking you to give me the correct answer and probably even have an explanation given to the fact that you choose A or B, that is one or two, yes and or no. We'll take a break, and when we come back, we're getting into that main discussion where we're looking at applying successfully to remain in the UK based on your private life. And I know definitely we'll be getting into some definitional issues, private life, remaining in the UK, and then look at how we can do that without fail. Lawyer Charles Asma will be a resource person and guest from BWF Solicitors, our trusted partners when it comes to the law. It's the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. I see there's a lot of activity on our social media platforms, down in the comment section on Facebook and YouTube. Those of you there, thank you. Gloria Frimpong, Julian Nee, Latte, Odisha Banana, Kwekume, Patrick Griffin, Gerard Agbat, all of you are on there, and you have announced your presence, and on our YouTube channel as well. Those of you on there, thank you very much, and well done for sticking around. Now the question is, private life, application, immigration application, how to do that successfully. Let me start off with a bit of the definitional issues, and Lawyer Charles Asma, as I said, is here to help us. Lawyer Asma, somebody wants to apply to regularize their stay and also remain here in the UK. what does the person have to do? What kind of application has to be put in? And then I would there add that what are the conditions to be met before somebody can make a successful application? Then maybe we then go on to look at why private life. What do we mean when we say private life? I think the ball is squarely in front of you, and I know with your sense of method, you will take us through that. Now let's see what applications we're looking at now.
Thank you very much. So today's conversation borders on private life applications. And with private life, I'm mindful that you asked whether there are options. So we're just going to run through the options and settle on private life and zoom in the conversation on that.
Okay.
So there are different applications that an individual can apply to remain in the UK. One is employment. So they can obtain employment and the employer will sponsor them. That is if they qualify. Two, they can apply to become students and the university will sponsor them, not money, but be the one giving them admission with sponsorships. And they apply if they qualify and they can do it in the UK. Next is family life. They apply to remain in the UK on the basis of family life. Or they are in the service, which is armed forces, air force, or any other armed forces areas. And they apply to remain on the basis of their service to the crown. Then they come to family. Family. They have family in the UK, and therefore they want to exercise their family life to remain with the family. Then we go to private life, that they've lived in the UK and therefore their long residence in the UK should give them opportunity to continue to remain in the UK. Or they are afraid to return to their country and so they want to remain in the UK on the basis of humanitarian protection. So these are different options. Now, we want to settle on private life because that's the context of today's discussion. What is private life? Private life means that you have formed connection, association, and the place where you live has become your home or community. And because of community ties, social ties, and network and everything that you have formed in that new environment, going back to the old environment will be detrimental because you might have lost ties or severed ties with that old community, i.e., your original home country. And so you want to say that having remained in this environment or having been in the UK, for example, for this length of time and having several relationship or ties with your home country, if you are to be sent away, you will struggle to survive because there will be nobody, no network, no ties. And so you should be considered. On that basis, you will be considered.
Now, if we talk about private life, and you have mentioned severally length of time, what length are we looking at? 2 years, 5 years, 7, 10, 20?
Right. So we come to the duration when we open up the conversation. But at the moment, we are looking at the contextual matters.
Okay.
So the context is that because you have formed new community or network or ties in the UK, the only place potentially you know or you have come to know is UK. Now, if you were to be asked to leave, it will not be fair. And so under Article 8 of the European Convention on Human Rights and also under the Human Rights Act 1998, you should be considered to remain where you are because you have formed a new life in that area, which is not based on anybody but yourself.
Mm-hmm.
If the life is based on your family, then we say family life. But this is based on yourself, so it's private life. Private doesn't mean that you are in a corner private somewhere, but simply that you have lived your life and you are living your independent life in that community. And so they have to consider that community life you have formed or you have. Now the question is, what constitutes length of time as to form a private life? It becomes a definitional matter. So we'll take you to Appendix Private Life, where the government has stated that to define private life, you have to look at a number of years the person has lived in the UK.
Mm-hmm.
And here we are not looking at whether they've lived documented or undocumented. It's about residence. How long have you been around for?
Okay.
So under Appendix Private Life, which is the guardian document for caseworkers, it says that if you look at paragraph PL 5.1, so producer will take us to PL 5.1. If you look at residence, under residence. So under residence, yes. So if you, open the, go, it says hide, isn't it? Yeah, so if that's it. So if you look at 5.1, as I earlier mentioned, there are two parts to 5.1. First one is to do with somebody 20 years. So the first one says 20 years, adult, 20 years. So if you're an adult, you must have lived in the UK for 20 years to form a private life. Or less than 20 years, and that is where it could be 1 year, 2 years, or whatever. Less than 20 years with issues that will affect your life if you were to be sent abroad. However, there are different categories of people. So far, 5.1 is about adults. An adult is somebody 18 years and above. What about children? So under children, if you look at 3.1, for example, it will tell you that with a child, we are looking at the time, if the child is under 18 years, then 7 years in the UK. If the child is under 18 years, 7 years in the UK is private life. What if the child is more than 18 years, but less than 25 years? And that will take you to paragraph PL 4.1. So paragraph PL 4.1 says that if the child or the person is a young adult between 18 and 25, then we are looking at half of their age should be their residence in the UK. So if the person is, let's say, 19 years, 24 years, so 18 to 24 years, then we are looking at half of their age. So the applicant must have spent half of this, is at least, but we are looking at the minimum. And so half of the age continuous residence in the UK. And here it's about mathematics. So we're looking at, for example, somebody who is, let's say, 20 years in the UK. They want to apply on the basis of their private life. In this case, how long should they have lived in the UK for? The person is 20 years.
They should have lived about half of that life for 10 years.
So half is 10 years. So definition of private life for somebody 18 to 20, somebody who is 20 years in the UK, but more than 17 years will be 10 years because they are 20. At the time they came, they were under 18.
Mm-hmm.
But maybe they haven't lived in the UK for 7 years to qualify under the children criteria. Well, under children criteria, if the child is under 18 years and they have spent 7 years, they get indefinite leave to remain on the basis of private life.
Mm-hmm.
We move to now the child, at the time they turned 18 years, they had not lived in the UK for 7 years. Maybe they have lived in the UK for 6 years and 10 months. Nearly there, right?
Mm-hmm.
Unfortunately, they didn't live, quote unquote, to see have 7 years, because they became 7 years when they had turned 18. Then that would take them to 18 to 25 years. Then we look at how many, then it says 18 to 25 years. Unfortunately, you have to do 10 years, or you have to do half of your age. So we have to then calculate what is half of the age of the child or this person if they are still within this age bracket. So that one is not enough to simply say this number or that number. You take pen and paper and calculate
Calculated.
what
Okay.
will be half of the age at the time they want to apply under private life. So that is that one. Then we go to adults, which is defined either 20 years or less than 20 years with insurmountable obstacle.
Now, what I'm thinking of again is, apart from the length of time, sometimes people have circumstances in their life that may fall into the private life category. For instance, some unsurmountable circumstance where they may not be able to go back to where they came from. Would that be considered, or is the law saying that you have to have the length of time and or the um, unsurmountable circumstance, or the two would have to go together, lawyer?
So paragraph PL 5.1 is clear. You either settle under A or settle under B. Producer, please take us to 5.1.
Mhm.
Please read A for
Yeah,
us.
so the 5.1 says where the applicant is aged 18 or over on the date of application. A, the applicant must have been continuously resident in the UK for more than 20 years, or where the applicant has not been continuously resident in the UK for more than 20 years, the decision maker must be satisfied there would be very significant obstacles to the applicant's integration into the country where they would have lived if required to live or leave the UK, so to speak. So
So
I think I want to repeat the second one. Where the applicant has not been continuously resident in the UK for more than 20 years, the decision maker must be satisfied there would be very significant obstacles to the applicant's integration into the country where they would have to live if they leave the UK.
thank you. So producer, thank you so much. So you can see that for adults, there are technicalities. So when a
Mhm.
client comes to me, I ask them, are you private life A or private life B?
Okay.
Private life A means 20 years. It says the law says more than, the rule says more than 20 years. So somebody will ask, but then why do you lawyers always say 20 years if the law you have read to us says more than 20 years? This is the reason. You cannot apply if you are not 20 years. So let's say 20 years is today.
Mhm.
So you've come to me, oh, today I'm 20 years. Then the application will go tomorrow, right?
So it's more than 20 years, 20 years and a day.
And a day, that's more than 20 years.
Okay.
So,
Well, at least
yes,
the base should be 20 years.
but it says more than 20 years. It doesn't, so that means it should be at least 20 years
At least 20 years. Okay.
at the time of application. If you are less than 20 years by a day or an hour, then the application will be refused that you have not formed adequate private life
Okay.
under A. What about somebody who does not meet A? Can we consider? You see, there's a reason why the framers of the rule considered somebody who has done less than 20 years because it's part of us. It's possible that somebody who has not lived for the full length of 20 years, but sending them away will not also be good for them.
Mhm.
And so they said that either 20 years full stop or 20 years plus issues.
Okay.
So what is 20 years, less than 20 years plus issues? Less than 20 years plus issues means you have lived in the UK for, let's say, 1 year.
Mhm.
That's less than 20 years. But you have so many issues to the fact that if you are to be sent away, your life will be at risk. And what do we mean? Maybe you have, over the period of living in the UK for less than 20 years, been affected by illness. And so your life has become so critical that if you are removed from this environment, you are prone to death. And there's no way you can overcome the challenges that await you. Is that insurmountable obstacle? Yes, insurmountable simply means that you cannot overcome the dangers that lie ahead.
Okay.
And what are these dangers? Imagine somebody who has been declared or who is in his or her palliative state. Palliative state means that a person is nearing death because of ill health. Maybe they have 10 years to live. And you are saying that, oh, they haven't done 20 years in the UK, so they have to go away. Come on, this person has 10 years to live. There is insurmountable obstacle ahead. If you send them away, how would they cope? They are receiving treatment and all the necessary support. So if you send them away, how would they obtain that support? That's an insurmountable obstacle lying ahead. The person has maybe undergone or experienced disability whilst living in the UK. You ask them to go. How would they cope? They came to the UK with 2 limbs. Now they are left with 1. You want them to go and survive there? It's not going to be possible, commonsensically. And so you can argue that I have insurmountable obstacle lying ahead. The person came in, whole health, and now they are going through mental health breakdown, serious one. So they are going, so they are receiving treatment, counseling, and all forms of support because of this level of depression, level of stress, anxiety, and what have you. They are on all forms of medication, and you want them to go and survive. Commonsensically, it beggars believe that if they go, they'll be able to survive. And so there is insurmountable obstacle ahead. But it's not enough to say that I have these obstacles. The game is simply on the basis of evidence.
Evidence, yeah. So I'm looking at people who probably have suffered domestic abuse one way or the other. Would that qualify as an insurmountable circumstance?
Domestic abuse matters are different.
Okay.
Because if you came to the UK to join your husband or wife, and your husband or wife is subjecting you to abuse, you as a victim of abuse, you have remedy under the same law, which says that if the person who sponsored your application to the UK, that is your spouse, is abusing you, come to us. If I say us, go to the law. The law says that if you come to me, I will give you rest. And the rest is that we'll jump you from you being under them to you being on your own. So we'll give you indefinite leave to remain, provided you can prove your case.
Okay. Well, if you just joined us, we're live on BWTV, and the program is The Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. They help us with this pieces of educational program. We have one on Thursday, one on Friday, and Saturday afternoon on The Community and the Law. BWF Solicitors is there for you to approach when you have issues with your immigration matters, any form of application, interpretation of the law, any advice, and of course, helping you to make your appeals and getting them through successfully. You can call BWF Solicitors on 0208 493 7340, 0208 493 7340, or if you're in Ghana, they have an office in Ghana. You can reach them on 055 589 5959, 055 589 5959. In emergency situations, call 077 127 61884, 077 127 61884. We're live with lawyer Charles Osma, who is also from the stables of BWF Solicitors. And if you want to reach out to him, you can call him on 07947 636037. 07947 636037. BWF Solicitors are trusted partners. Now, somebody was asking what number they could text or send a WhatsApp on 07399 208 468. A brother on YouTube, thank you very much. 07399 208 468. I have a couple of them that we will be looking at very shortly. But after this very brief break, we will come back to Lawyer Charles Osman and we'll look at how we can successfully make an application when now we have really looked at what the threshold is, what conditions you have to meet, and especially when we define in private life. And there are two main private life conditions under this criteria. We're looking at where you would have spent 20 years here of your life. And then it also talks about if you are less than 20 years and then you want to make the application, you would have spent half of your life here in the UK. Then the second scenario is you don't have the 20 years, but you have some unsurmountable circumstances in your life that would help you do that. Think of these two. If you have any question, just come back to us. I will do that. But then let's take this short break and we'll come back to look at how the application is made. It's a community and the law brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Well, so yes, you can send your text to us on 07399 208 468. You can send your WhatsApp to that number as well, 07399 208 468. We're live on BWTV, brought to you by BWF Solicitors, and we're looking at how to successfully apply to remain in the UK based on your private life. And we are doing this with lawyer Charles Osma from BWF Solicitors. The number, thank you very much. Yes, the number is correct. So you are on Somebody comes in and says, "My name is XXXXX." I will put your question to lawyer later on. Keep them coming through. Our friend Queenly One, yes, you can call us if you really want to. But then now we're going to look at how we can successfully apply to remain in the UK. Lawyer, how do we go about it?
Thank you very much. So the law or the rules provide the pathway and what you need to be able to navigate.
Hmm.
First off, we have to point out that it's a matter of evidence. We also want to confirm that there's case law that what you are proving is your residence and nothing
Mhm.
else. So if you are proving residence, it doesn't matter how you obtained the residence evidence. As long as the residence evidence is genuine, it is acceptable. Now, we are going to have a plethora of evidence. And that is why I said that as long as the evidence is genuine, it is acceptable. And so it doesn't matter how the evidence came about. So you get to understand. So the first is to say that I have lived in the UK for 20 years or half of my age. Or if I'm a child under 18 years, 7 years. One, what, so the first thing to provide, if you have it, is the stamp in your passport, the visa stamp in your passport. When you enter UK, the passport or the visa is stamped and you have a date. That is the starting point.
Mhm.
You enter UK, you register a GP. So you have GP or NHS card. That is another evidence. Some people will enter UK and they are fortunate to find a job. They will be working even though they are not supposed to. So in one breath, they've done the wrong thing by working. But in another breath, they've done the right thing by obtaining evidence of their residence.
Mhm.
We are proving residence, not whether you worked or you didn't work. And therefore, we are not interested in the legalities around your work. We are interested in the legalities around your residence. So you have provided pay slips that has your name, has date, and address that was issued in the UK. Genuine. Then that's enough evidence that you were in the UK in those material periods or moments. You open a bank account, so you have bank statements. That is also a piece of evidence that you were living in the UK.
Okay.
You've been attending hospital or GP for so long. And so you can even trace back to when you started living in the UK. You can get all that from your medical records, and that is evidence because there will be dates you attended those hospitals or clinics or GP.
Mhm.
Somebody will say, but lawyer, I have not been attending the GP, and so I don't have much. Well, unfortunately, there isn't much that can be done about that. We are talking about the fact that if you have it, then you can use it.
Okay.
So it's not when you open the GP or registered with the GP practice, but it's the record you have up to this point that will support your claim that you've been living in the UK. But the point here is, if you are not living in the UK, how come there's evidence that you were attending the GP? So that is one evidence you can add. Some will take photos. In the past, we have digital cameras that took photos and had date, time, and location at the back of the photo or front of the photo somewhere. I don't know if you've ever come across such photos. So such photos can be used as evidence
Mhm.
because it has you in there. So we can see you there.
Okay.
We can see a date on there because it's printed digitally there. We can also see location. For example, there's one application I did, and the person photo showed Peckham landing, and that
Mhm.
is evidence enough that the person was in the UK. Colandon is in the UK. Peckham is in the UK. So it's not a full address, but a
But
pointer
at
to
least
that
to,
this is
to evidence that you were somewhere in the UK.
exactly.
Okay.
Then, so you have your face in the photo, you have a date on the photo, and you have a location on the photo. That is evidence of UK residence.
Okay.
Somebody will say, oh, but what if I write? If it's a matter of writing, then you can even bring your photos from abroad and write on it. So they will not accept it. It
Okay.
has to be digitally printed, not a typewriter to type, but it's already in there. That is enough. We can argue about that.
Somebody's just asked the question that in this day and age, there is the NHS app on which you find all your medical records. Would that be evidence enough?
It's not finding your record, but providing your record.
Okay.
If you find your record and provide it without going to your GP, of course, you print all of them. But normally you go to the GP so that it will show that this is coming from the GP.
Okay.
And that is even better than you printing it yourself.
Printing it out of
If you can get it online, it doesn't really matter how you get it, provided it's genuine, authentic, verifiable, and has the date there.
Okay. Now, back in the day, oftentimes you tell us that you can also get evidence from people, credible people within the community, your doctors, your reverend ministers, your imams, community leaders, and all that. Can we use those evidences as part of building evidence towards your private life and the length of time you have stayed in the UK?
Okay, so let me ask a follow-up question
Mm-hmm.
with a view to answer your question. Pardon me that I'm asking a question
No,
to
that's fine.
right. You know, you and I appear on this show, and you know me. I know you. Will you write anything that is not favorable to support my immigration application?
Obviously, I know you, so
No.
I can
On the
vouch for you.
balance, you want to help me. Will you do that? No.
Yeah,
It will be
yes.
favorable. You won't write anything unfavorable.
Anything unfavorable? No.
Exactly. And so anything from friends, from colleagues, from pastors, imams, our leaders, our mentors, we call them self-serving evidence.
Okay.
And because they are self-serving, there's no way they will say anything bad.
Obviously.
That is why employers don't take references from family and friends. There's a reason. Because no family or friend will lie about you or say anything incriminating about you. But if it's coming from the GP, it is the record they have about you based on your attendance that they have put together and given to you. So that one, we say it's authentic and verifiable. If it is coming from HMRC, your tax record, it's verifiable, it's authentic, because there's no way they can print that if it is not true.
Okay.
If it is coming from bank, there's no way a bank will open an account for you if you haven't requested. And there's no way a bank in the UK will put a figure on your bank to create a statement for you if it is not a transaction. And so all this put together, because they can verify, they are happy with it. But there are instances where they verify and it comes out that it is not true. And so the caution is make sure it's authentic.
Okay.
For this day and age, it's not only elsewhere. Here in the UK, people are able to get something. So please be careful. Because there are instances where they will come back to say that we have checked with energy company and this is not there. That is not there. So please be careful. So long as all your evidence provided are genuine and verifiable, you've ticked the box.
Okay.
So we are going through the different evidence you can provide. Pay slips, GP record, NHS card, voter card or poll card. So the poll card, you see that every election period, they will tell you that take and go and vote. Commonwealth citizens are required under the law or allowed under the law to vote.
Mhm.
And so you register with your electoral area officers. They send you a letter. That letter has your name and address and date. Does the letter prove that you were in the UK? That's why they sent to you.
Okay.
That's your residence
Mhm.
evidence. The polling card sent to you to go and vote. Does that suggest that you were living in the UK? That's why they sent it to you? Yes. HMRC document. Yes. At the end of the year, they write to you to
Would
say
particularly a P60 be sufficing?
all forms of HMRC record, a letter to say that you owe them money, a letter to say that they owe you money, a letter to say that you have to file self-assessment and you are late, a letter to say that they are doing XYZ about you, a letter to question you about your NI. All these are good because they show that you are in the UK. That's why they wrote to you,
Okay.
including, of course, P60s and P45s and P46.
Okay. Now, the next question then is, um, when I have provided all these pieces of evidence, would it then become a tick box affair, or the caseworker would still have to use his or her discretion to grant this application?
So this is not a discretionary application. It's a checklist based application or
Okay.
criteria based application.
Okay.
Criteria is show that you have lived in the UK for 20 years. So you start from when you entered. We are in 2024, December. This person entered, so 20 years back, that would be what? 20,
December
2004, right?
2004. Yes.
So 2004 December, let's say 13th of December you came. So 14th of December today is 20 years in the UK. You want to apply. First, where is the visa that was in your passport that was stamped at the airport? Do you have your old passport? Yes. Oh no, I don't have it, but I have a copy somewhere. Go and bring it. It shows that you entered Heathrow or Gatwick. Stamp. That's the starting point. When you came, did you register with GP? Yes. Oh, I have it there. Go and bring it. GP, old paper, tattered, but we can copy and make it straight. Evidence. Did you register with GP? Can you get the evidence? Oh, yes, I've been going every year. I'm very good at checkups. So I have a lot. Go and bring all of them. You have bank account. Oh, yes, I opened. When I came, lawyer, I remember when I came, I started a course, a computer uh, class at this place. I've completed the course and I was given a certificate. I have a lot of letters from the school and that college. Go and bring it. That's evidence.
Mm-hmm.
So all these pieces can support your claim that you've lived in the UK for 20 years, plus the ones I have already mentioned. But the key thing is they must be genuine and verifiable.
They must be genuine and verifiable, and those evidences will help you satisfy the criteria, and then your application will be successful. Next question, and then we will bring in your questions and concerns. What is the fee, and how long does it normally take?
The fee is £3,845 50 pence. IHS 2587.50, and the visa fee is 1048. Total 3845.50. That's the fees to the Home Office.
Now, when we're breaking that, you scared me. You said 3,000, then the breakdown was adding 2,000 and 1,000. And I was like, are we getting close to about £7,000? But yes,
No.
thanks for the clarification.
I was breaking it down.
Yeah, I missed the heartbeat. So what? I think we have to spend that much. Well, in any case, if you want any further clarification, say that again.
However, people should not be scared, because under Section 6 of the Human Rights Act 1998, if they force you to pay, even when you cannot afford, that would be a breach of the law, because Private life is a human right, and so exercising your right and being not able to afford, they cannot force you. You can go for fee waiver and get it for free.
Well, we'll be looking at how to successfully apply to remain in the UK based on your private life. Folks, if you have any question, if you have any concerns, or any other question out of the realms of what we have discussed, the lines are active now 0208 493 7345. Send your text or WhatsApp to 07399208468, or leave your questions and comments in the comment section down below on Facebook and YouTube at BWF Solicitors and at BWTV. Quick one to give you our social media handles, and then we come back to pick up your questions and concerns. Now, remember, I gave you the nugget and my scenario for you to ponder on, and I will be bringing that to you to help me solve. And then we'll ask lawyer Charles Asma whether our answers were right or wrong. It's the community and the law, brought to you by BWF Solicitors. Now watch these handles and follow us. We have Jallo Michael Teta just following us on Facebook. Thank you, Michael. Thanks for your follow. And Gerald, Sandra, Ade, Taribo, and the host of you have also shared. If you haven't done any of these, share now and let's keep going. And then we would also want you to click on the notification button so that when we put up any content, you will be notified and you don't miss out. Then also invite people to come for the live event. Now, when you miss out on the live ones, the links and the full programs are on our social media platforms, so, Facebook and YouTube. You can go back for as many years as we've been here, and you can play back and get as much information as possible. I mentioned that we're looking at how to successfully make an application to remain here in the UK based on your private life. Lawyer Charles Asma, a resource person from BWF Solicitors, is available to help us answer your questions and concerns. The lines are active. Again, I say they are 0208 493 7345 or 07399208468. Send WhatsApp to that number as well. I have a couple of questions that we will be handling. But first of all, let's see what this voice note says.
Good evening, Lawyer Asma. Good evening, Brakwaku, Edamasi, Community and the Law, the Mopo Society, and I'm going to food in our mama. Quick question, I'm a cousin. But I'm not so self naturalization. No, EU, a study family member. I think we're trying to 5 years when you need different, they win a menace for application. Now, question is, first of all for the application, they will say, do you have a national identity card? Or no, Ghana, no, Ghana card, and the community, or nobody could take whole years, not the Ghana card, no national taking because higher UK. 2, series of applications you made, previous applications you've made, both outside the UK and Hano. Why your application may be answered or different on card date in the home, what can they say? On taking indefinite or an unknown one, because and your card date in the bad card on kind. Thirdly, that was say, have you been arrested or charged at a conviction? Because one, I'm only the girlfriend and our be Emma police be getting that or assault to know. Police for betching the point, only interview and a dead and Billy man the fee. And I get a crack as on person child, connect malicious intention. na police for no says they lack evidence, so no further action taken. Eco social because not social force we charge in no case, case closed. And I'm let up say case closed and a police force no further action taken. So that's only declare on application say yeah, by moment yeah charging and no further action. And I said because not a immigration board, no some just say arrest okay because we go with my arrest no innocent and then just say convict to another charge no I will declare. But the person must say on declare now on an application, no sign your competent to no case no further select and I said on declare or declare the problem be plan so you could and I said or declare so before my that's only good with that.
Okay, this gentleman is asking a couple of questions. National card. Can he use a Ghana card for an immigration application here in the UK? Declaration, and also he's been asked whether he's made several applications before. He only remembers one of the dates; the rest he doesn't. And then he had a case with the police. No further action letter was issued him, both social services and the police. Does he have to declare these?
Thank you very much. So, national identity card question is on the form. The question is, do you have it? It says, do you have a national identity card? So if you have national identity card from your country, you can say yes and put the details there. If you don't have it, or not everybody has it, or might have been issued with one. So if you don't have it, you say no. If you have it, you say yes and put the details there.
Okay.
Question number 2 is to do with things I don't remember about my past immigration matters.
Applications.
What do I do? If you are not sure, don't gamble. Do subject access request. Get your detailed report or information so that you can tell all the applications you've done to the UK and you can check to know exactly what to say. Because if you say no and it is yes, you've told a lie, it will go against you. And if you say yes and you can't give the details, you cannot move to the next stage. So if you're not sure, stop, request your data from the Home Office so that you can be sure what information they have to use in this application. The third one was to do with
no further action letter giving him
criminal arrest and charge. So the application asks, have you ever been arrested or charged? So it's 2 in 1. Somebody might have been arrested but not charged. Somebody might have been arrested and charged and convicted. So if yours is an arrest, because there was an arrest or caution or warning, whatever, say yes and give details as he was pointing out. You can do that. But if there was no arrest, they just called you that we are doing something, we want to be sure, blah, blah, blah. And they came back to say no further action, case closed. If there was no arrest, you know. If there was arrest, you know. So if there was arrest, please say yes and give the context.
All right. 0208493745. Hello.
Hello.
Yes. Good afternoon.
Yeah. Good afternoon.
Yeah. Thank you for calling. Let's hear you.
Yeah. Please, I want to speak to you. Okay.
No problem, Yanko.
Okay. But I'm just going to start by accepting the application. Number 10 year resolution. May for investigation. Now, almost like evidence. I guess I'm in the manage. Now, almost to report appointment. Yeah, if you address any so long.
Yes, Laura, she wants to find out whether letters, school reports that do not have the home address on there, would that be enough evidence to add to the application after 10 years?
But Madam or
lawyer no kasa.
I try to say.
But what I said to say.
But apart from school report, then ever fear about umano.
I then time appointment I have for no address and so yeah no sure in time any date the pet.
Nti sɛ wopɛ biribi a ɛkyerɛ sɛ wo ne wo ba na ɛte something with address what will you do?
Baako pɛ deɛ na menya mmienu deɛ menya panyin ne deɛ no deɛ menya di bankwa ne mmienu deɛ.
Nti nkwalaa no mmienu no, what can you do? Well, but this is fact. That's why I've taken my time to work with you. Imagine sɛ wopɛ sɛ yɛhu sɛ so wobɛtumi akɔ GP akɔ request a letter to confirm sɛ wo ba no ɛte address sɛ wo ba no register no wɔ GP meboa.
Mepa try
Wo register wo ba no GP wɔ baabi a akwalaa no ɛte ɛwɔ ɔmo record so anaa?
Mepa try.
Nti woka kyerɛ GP sɛ you want a letter by your child say you register wɔ hɔ ɔmo confirm a ɔmo ntumi nyɛ.
Okay. Okay.
That could that be an option?
Yeah.
That's why I was asking, what can you do? So this is something you can do. You can also get a letter from the school because you tell them that you need this for that. They will, because that's what they have on record. So they can provide a letter stating what they have on record about the child's residence.
Okay.
Answer a question, Omeba. Very good. Okay, so yes, 0208493735. Let's pick some comments and questions from the various platforms, Facebook and YouTube at BWF Solicitors and at BWTV. I made a fee waiver application on 2nd of February 2024. Section 3C was in place, so I was working. In August, my employer stopped me. I told them I got fee waiver application pending. They said their checks with Home Office shows negative verification. So I was sacked. Last month, I emailed the Home Office complaints team. They replied that the decision was made and sent via email on the 4th of July. However, nothing has been received. I've checked my spam, junk, inbox everywhere, but nothing. So technically, it's the Home Office fault not sending. I've emailed their review team for further query. Lawyer, what should I do next? What's your advice since it's not my fault, but that of the Home Office?
Right. So it's strange that they claim they have and you claim you haven't received it. So what you can do is to send them a pre-action protocol letter stating the issue and why you think they have not done what they claim they have done and what this has cost you and why they have to fix it so that you can continue to exercise your right or protection under Section 3C. Once that happens, their record will be updated. So the employer will carry out another ECS check and it will show positive for you. So you have to literally take action in a way against them. Pre-action protocol letter simply means that you want to take them on, and this is a letter to them. So you can do that.
Okay. Well, let's pick up another one. I know there are a couple of them there. Please, I live with my uncle in his rented apartment. I have a British child whom I'm solely responsible for. I am applying for leave on 10-year parent route. I meet all the other requirements except the English language, financial accommodation, and immigration status. My uncle will provide documents to support, but his earnings is £800 per month. He gives me £150 and groceries per month. Is his financial circumstance enough to support my application? And then he's asking, do I need to do the English language test?
Right, thank you very much. So this application falls under Appendix F1 EX1. EX1 are the exceptional circumstances that can apply to people like this. And our friend is saying that she lives with the child, so wants to apply on the basis of the child. 10-year routes are for people who do not meet the rules, other aspects of the rules. And so, if it is the case, don't worry about English because it doesn't apply. Don't worry about money because it doesn't apply. Accommodation, your uncle can write a letter to confirm that you live with them together with your son or daughter and that he supports your feeding and accommodation. If you don't have money to apply to pay for the fee, you can apply for a fee waiver because from what you've told us here, even though I will need a lot of evidence to test your chances of getting a fee waiver, you can apply for a fee waiver as well. So nothing to worry at all. You are good to go.
Nothing to worry about. You are good to go. And this program gives you the opportunity to weigh your chances and know what it is. And BWF Solicitors is right there to help you. Keep them coming through. Let's pick up another one. Approximately how much would it cost to appeal a refusal decision in court for entry clearance as partner of British citizen? In general, approximately how much is barrister's fee, lawyer's fee, and court fee? The refusal is based on relationship, which actually is genuine and subsistent lawyer.
Okay, all right. I know you know, but let me add to what you know. So what it is that the court fee is £140 if it is one application, one appeal application. If it's two, then times the number. So £140 per appeal application. Lawyer's fee depends on what the lawyer tells you. So I will not be able to say that X amount for lawyer's fee because I wouldn't know which lawyer you'll be seeing. The third one is the barrister fee. Again, there are many barristers, and so depending on which barrister you go for, depending on the issue to be addressed, the fee will be different. There is a barrister I got for my client, and the barrister charged £2,000 for appearance and the person was ready because it was a very serious matter. So we went for the top barrister. But depending on your level, I can't say that it's X amount. And you agree with me that I would be wrong to quote a figure for a barrister fee or a lawyer fee. But the court fee doesn't change, at least for now, and it's £140.
Keep them coming through. Let's pick up another one from the various platforms. This one from Facebook. I'm a student dependent. My husband didn't pass all his subjects. The school refused to give him a letter to renew his visa, which will expire next year. Now, he decided to go to Ghana and back next year for a reset. I don't want to follow him to Ghana. What should I do to get mine renewed to stay in the UK, lawyer?
Right. So, Perpetual, this is a case of till death do us part. Unfortunately, your husband has decided to leave. And because you tag along your husband, ideally, you have to go with him. And if he's returning, you come back with him. If you choose not to go and you want to remain in the UK, of course, you can live your life. But at that point, you will be without leave. If you are without leave, what can you do? If you are without leave, under Appendix FM, people without leave or people who have leave and have children who are British children or EU children can apply to remain on the basis of the children's status. So if you choose to stay on and you happen to have a child, you can apply on the basis of the child. However, because you came with your partner and you are, of course, married to your partner, if you are not divorced at the time you have your child, the child father will be that partner, and so it will not serve any purpose within the rules. So that is something to consider. Can you remarry? Marriage is open, and that is natural. And so if for whatever reason your marriage, because of this situation, there are issues, and that issue is creating instability in your relationship or marriage, and there is divorce, of course, you are now free to marry. And if you marry and you are able to prove that the new marriage is not for anything else but marriage, and the husband is somebody able to sponsor your application to remain with him, then that is an option you can consider. Otherwise, you have to wait till you are 20 years. If the rules have not changed, then you can apply under private life. So these are of course, I don't think you will consider the third option. So the two options are the ones you have. Now, at the moment, you are dependent. If the visa is not ended and you switch because you've gotten a job and the employer is sponsoring you, you can also switch to skilled worker if the visa is still active or valid.
Well, we're live on BWTV, and we're doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. Located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And if you want to contact them during the weekends, just call and book an appointment and they will make an arrangement for you. Call them on 0208 493 7340, 0208 493 7340, or 077 127 61884. If you want to reach lawyer Asma directly, call him on 07947 63 6037, 07947 63 6037, and he will have all the time in the world for you so you can get through all your applications quite successfully. This afternoon, he's led us to look at how to successfully apply to remain in the UK based on our private life. And at least you know that you should have spent 20 years from the time you entered, and or there must be some exceptional circumstance, unsurmountable circumstance in your life to make you apply when you have not spent 20 years. Now, if you are aged between 18 and before 25, you would have had to live in the UK for at least half of your life. And then he's giving us all the conditions and the things we need to consider before we can put in that application. If we satisfy all those bits, then it becomes a tick box application, and it's giving us at least you need over £3,500 to make that application successfully. Not looking at what the lawyer, whoever is putting in the application, will charge you. Those are the home office fees and the visa fee and all that. Then also the national health surcharge, that one as well. Well, earlier on, I mentioned to you that I was going to put a scenario before you, and I did, based on the nugget. So let me quickly look at the nugget before I come to those questions. The question was, is there a time limit for disciplinary action at work? And we said in the UK, there's no statutory term limit explicitly set in employment law for how long an employer has to initiate or complete disciplinary actions. However, employers are expected to act promptly and handle disciplinary matters in a reasonable and timely manner to comply with best practices and employment law principles. There's a case that we looked at, Williams versus Leeds United Football Club. And in that case, the High Court found that, in principle, there is no limit on the length of time that can pass between an employee's gross misconduct and their dismissal without notice if the employer was unaware of the employee's wrongdoing during the time. So based on this and the explanation that lawyer Charles Asma gave, I gave you the scenario that consider and give me the correct answer. Kwame Abbas was initially made redundant, but was summarily dismissed after his employer found that over 5 years previously, he had forwarded an email containing obscene and pornographic material to a junior female employee and two friends who were working at clubs. The employer sacked him summarily, although his contract required that he be given a 12-month notice period. Subsequently, he sued for breach of contract and for salaries in lieu of the 12 months notice. The question I ask is, will his claim succeed because he has not spent 12, or he was not given 12 months notice? The two answers. One says yes, as his contract stipulates a 12-month notice, it ought to be respected. The other one says no, it can't be, or his claim can't succeed because the offense is gross misconduct, which does not require a notice period. Now, think about this after the short break. When we come back, I will ask you to give me your answers, and then I will explain before we draw the curtains down. So, watch this bit about our social media handles and follow us, please. Welcome back. So let's get your answers. Let's see what you have. Is it yes or no? Yeah, our team says yes. As his contract stipulates a 12-month notice, it ought to be respected. Yeah, we see what lawyer tells us. Joseph Isaiah also says same. Then we have Franco says saying yes, as his contract stipulates a 12-month notice, it ought to be respected. Well, I think Anasewa says no because the offense is gross misconduct which does not require notice period. His claim will not succeed. Sandra Kusi, the contract, I think that's what you mean, explicitly requires a 12-month notice period. Okay, so you go with number one. Thank you. Emilian Kruma says number two. Who else has anything? Jose Champon says number one. The 12-month notice has to be respected. Eunice thinks so as well. Who else? Kofi Apia says yes. His contract stipulates a 12-month notice, so it ought to be respected. Solomon A says number two. He doesn't agree with the rest of you. Solomon doesn't agree. He says that gross misconduct, so it doesn't require notice period. Gloria also thinks so as well. Tilly says number one. Okay, so I think for time, I will quickly go over to Lawyer Asma to ask, based on the nuggets and the scenario here, what the right answer would be. Will Kwame Abbas's claim succeed?
Thank you very much. Now, the only time an employer must serve notice to terminate is if the contract is coming to an end, or there's some aspect that suggests that the contract cannot continue. Employer must serve notice, employee must serve notice. There are instances where the employer does not have a duty to serve notice, where the employee has breached his or her terms of engagement, including conduct, what we call the code of conduct. In this case, if it's gross misconduct, the employer can terminate without notice. So that is point to note. So if it is summary dismissal, it means it's a dismissal that does not require notice. Summary. Now, we are told that this person offended some time back, 5 years later, is being found out, and they are terminating him summarily without notice. Is it fair for the employer or not fair? Is it fair for the employer to do that or not? The answer is because it is misconduct, the employer can terminate without notice. This has nothing to do with fairness, and so the answer is no.
Well, notwithstanding an employee's basic entitlement to a minimum notice period on termination of the employment contract, there are occasions where, as it were, the decision to dismiss with immediate effect without pay or pay in lieu of notice would be an appropriate course of action for an employer to take. In particular, summary, dismissal will be construed as fair in circumstances of gross misconduct, which is misconduct that is so serious that it has irreparably damaged or destroyed the working relationship between parties. So, those of you who said two, you are right. Well, thank you very much. And those of you who also participated in the quiz, thank you so very much. But now, let's see what summary we will have before we draw the curtains down. Layasma.
So thank you very much. Viewers and listeners, the assurance is that you can apply to remain in the UK on the basis of your private life. That is 20 years in the UK if you're an adult over 25 years, for example, or 25 and above. If you are young adult 18 to 25, half of your age. And if you are under 18 years, 7 years in the UK. In all this, you have to show that you have been in the UK for that period. If it is less than 20 years, then you must show that there are reasons why it cannot be sent away, and that if you are to be sent away, you will struggle to survive or you struggle to live. And you have to prove it. With a medical report or whatever from your doctors, you have to prove it. Let's remember that in counting the duration of residence, you do not include time spent in prison. Time spent in prison. So if you are incarcerated, the period of incarceration will not count towards the 20 years. Even though you were in UK prison, technically you were without liberty. And so that does not count. Again, if you left the UK and come back, the time you lived up to the point you left will not also count. And you have to start the journey when you returned. So these are things we have to bear in mind when we are calculating the 20 years. In terms of evidence, it's every documentary evidence that prove that you were living in the UK and there is time or date on that and address. And it should be verifiable. It has to be genuine. These are the things we have to consider. And this is what we brought you today. Thank you so much for your time. Have a good weekend.
Thank you very much, Leas, as well, for your time. And to again to come join us for another edition, same time next week. We were live on BWTV, which was live on BWF Solicitors Facebook page and BWF Solicitors YouTube page. And then also we had the opportunity to share in our various networks. My name is Oreku Frimpon. I will want to say thank you again on behalf of Shilankra Patmodudu and my studio director, Professor Ade, for helping us to do this. To you, once again, thank you. Be good. Meet you again, same time next week.